CR 758, State of Ohio versus Courtney Lee. Mr. Lee is present today with counsel Allison Hibbard. Your Honor, we are set today for a change of plea. The defendant is going to be changing his previously entered not guilty plea and entering a plea of guilty to count 2 of the indictment, harassment with a bodily substance, as well as count 4, resisting arrest. Felony of the 5th degree and misdemeanor of the 1st degree. Your Honor, the state would be making a recommendation at the time of sentencing in this case for a community control sanction. Thank you.
Can I see counsel for a second, please?
Yes, you may. I mean, Your Honor, we can.
All right, that's fine.
Thanks.
Count 2 is the same officer, isn't it?
Yes, Your Honor.
Any agreements on sentencing here?
There'd be a joint recommendation at the time of sentencing for community control in this case, Your Honor.
Sir, does that all sound accurate?
It does, Your Honor.
And Mr. Lee, were you able to hear what the prosecutor and your attorney just had to say regarding what they believe your intentions are here this morning?
I was able to hear that, yes, sir.
They indicated to the court they believe it's your desire to withdraw your previously entered pleas of not guilty and enter a plea of guilty to count 2 and count 4. Counts 1 and 3 would get dismissed. We would defer sentencing to get some evaluations completed, come back on a future day for sentencing where there's no agreement between the parties there is an agreement between the parties regarding sentencing. There'll be a joint recommendation that community control sanctions be imposed. Is that your understanding of the discussions that took place between your lawyer and the prosecutor and what you want to do today?
Yes, sir.
Well, before I can accept your plea, I need to make sure you understand everything going on here. I need to make sure you understand what it is you're charged with and pleading guilty to, the rights you have and the rights you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine all these issues, I'm going to ask you a series of questions. If at any point when I'm asking you the questions, if you're unsure or unclear of anything I'm asking you, if you need anything repeated or clarified, if you need a moment to speak with your lawyer to ask her questions, or even if you want to ask me questions, make sure you let me know that because I need to make sure you understand everything going on, all right?
Yes, sir.
All right. On this change of plea form, you don't have any amount of time for the resisting arrest.
It's 180 days, Judge. I'm sorry.
So again, if you have any questions, make sure you ask, all right? Now let's get started. How old are you, sir?
I'm 34 years old.
Are you able to read and write the English language?
I am.
Do you have any difficulty with that or difficulty understanding what you read in the English language?
No, sir.
Are you a U.S. citizen?
I am.
Now, before you came into court here today, have you any drugs or alcohol of any kind?
No, sir.
What about within the last 48 hours?
No, sir.
Not even prescribed medication, nothing?
No, sir.
Now, you would have been served with a copy of the indictment in this case. It looks like you got it, very end of November, beginning of December of last year. Do you remember getting the document that sets forth what the charges are?
Yes, sir.
Well, in that document, you are charged with 4 counts, pleading guilty to 2 of those. So I'm going to go over those 2 counts with you. If you have any questions, make sure you ask.
All right.
But in count 2, what's alleged and what you're admitting to is on or about July 7th, 2023 in Willowick Lake County, Ohio, that you did with the intent to harass, annoy, threaten, or alarm a law enforcement officer, specifically Sergeant Jacob Cook, that you caused or attempted to cause Sergeant Cook to come into contact with a bodily substance by throwing the bodily substance at Sergeant Cook, by expelling the bodily substance upon Sergeant Cook, or in any other manner. That conduct constitutes the offense of harassment with bodily substances. It's a felony of the 5th degree. Do you understand what you're charged with and pleading guilty to in regards to this count?
I do.
Any questions about it?
No questions, Your Honor.
Now, in count 4, what's alleged and what you're admitting to is on or about July 7, 2023 in Willowick Lake County, Ohio, that you did recklessly or by force resist or interfere with the lawful arrest of yourself and or Christina Lee. That conduct constitutes the offense of resisting arrest. It's a misdemeanor of the 1st degree. Do you understand what you're charged with and pleading guilty to in count 4?
Yes, sir.
Any questions about that?
No, Your Honor.
Now, there are two other counts of this indictment that are being dismissed. Um, is that your understanding?
Yes, sir.
Any questions about either of those two charges?
No, Your Honor.
Well, then before I can accept your guilty plea to what I just read to you, two charges, I need to make sure you understand all the rights you're giving up. Now, give me 1 second real quick, please.
Yes.
All right. In regards to your rights, you first of all have a right to have a trial. Now, a trial could be to me as a judge, where I listen to all the evidence and I make that ultimate decision whether you're guilty or not guilty. But you do also have a constitutional right to have a jury trial, and that would be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. Those jurors would consider and weigh all that evidence, and then those 12 jurors would have that make that ultimate decision. And that ultimate decision reached by those 12 jurors would have to be a unanimous decision. That means all 12 of the jurors have to agree together, one way or the other, as to each charge, whether you're guilty or not guilty. Do you understand that?
Yes, sir.
Do you understand by pleading guilty you're giving up your right to have a trial in this matter?
Yes, sir.
Now, if you did have a trial, you'd have the right to have an attorney represent you at the trial. And if you could not afford an attorney, the court would appoint one for you free of charge to do that. Do you understand that?
Yes, Your Honor.
Now, at a trial, the prosecutor here would be representing the state of Ohio, and he would have what we refer to as the burden of proof. With him having the burden of proof, excuse me, what that means is that it's his job or his responsibility or obligation to prove you guilty before you could ever be found guilty. You're presumed innocent of all these charges, and that presumption of innocence sticks with you and remains with you until the state, if at all, was ever able at a trial to overcome that presumption and prove you guilty. Do you understand that?
Yes, Your Honor.
Now, when I speak of this burden of proof, since it's a criminal case, the burden of proof is what we refer to as proof beyond a reasonable doubt. And that's the highest burden of proof we have in our justice system. What it means, it's the amount of the evidence and the quality of the evidence the state would have to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of those charges I just read to you beyond any reasonable doubt before you could ever be found guilty of any of those charges. Do you understand that?
Yes, I do.
Do you understand by pleading guilty you're giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt at a trial?
I do understand, and I thank you for the depth of the explanation, Your Honor.
You are welcome. Now, in order to try to do that, if we did have a trial, the prosecutor would call witnesses to come to court to testify for the state by answering questions from the prosecutor. Once those witnesses were done answering the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same person's questions. That's called cross-examination. So she could ask him anything she wanted to, but within certain rules. Do you understand that?
Yes, Your Honor.
You understand by pleading guilty you're giving up your right to cross-examine or confront those witnesses that would come in here and testify against you?
Yes, Your Honor.
You'd also have the right at a trial. You could call your own witnesses to come to court and testify for you if you wanted to and answer your lawyer's questions. Now, you don't have to do that. You're not required to do that, but you have a right to do that if you wanted. Do you understand that?
Yes, Your Honor.
And you further can request the court issue an order. We call that order a subpoena. What a subpoena would do is it would force or make someone come to court and testify for you and answer your lawyer's questions if they weren't willing to come in voluntarily on their own. Do you understand that?
Yes, Your Honor.
Do you realize you're giving up that right?
Yes.
Now, you'd also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you didn't want to. That would be a decision or a choice that you and you alone would have to make. So what that means is that nobody else could force you or make you. Nobody could compel you to testify against yourself at a trial. If you didn't want to, I can't make you testify. But most importantly, the prosecutor here would not be allowed to call you as a witness and make you take the stand and testify and answer questions. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes, Your Honor.
Further understand that if we did go to trial and you were found guilty, you would have the right to appeal or challenge that guilty finding to a higher court, a court that's above me. By pleading guilty here today, you're giving up and waiving all the rights you have to appeal a guilty finding that I will enter if your plea is accepted, as well as any other issues you could have raised or brought to my attention up to this day. Do you understand that?
Yes, Your Honor.
All right, well, do you have any questions at all about these rights we've just discussed? These are all the rights you have and all the rights you're giving up by pleading guilty. Any questions?
No questions, Your Honor.
Do you understand them all?
I do.
You still want to plead guilty?
I do.
You understand a guilty plea is a complete admission of guilt. That means you're admitting to the facts being alleged by the prosecutor. We're not going to argue later you didn't do it or it's someone else's fault or anything like that. Do you understand that?
Yes, Your Honor.
Further, as a result of pleading guilty, the effect of that plea is that you'll be found guilty by the court, and then you will subsequently, on another day, be sentenced by the court. Do you understand that?
I do understand, Your Honor.
Now, as far as sentencing goes, you're pleading guilty in count 1. That's the harassment with a bodily substance charge. It's a felony of the 5th degree. This offense is punishable by a possible term in prison of a minimum of 6 months, a maximum of 12 months, or any whole number in that range of 6 to 12. Do you understand that?
I do, Your Honor.
Now, count 2, the resisting arrest charge is a misdemeanor of the 1st degree. This offense is punishable by a possible term of local incarceration in our Lake County Jail of up to 180 days. You understand that?
I do, Your Honor.
Now, you are pleading guilty to 2 charges. If I impose the prison sentence for the felony charge, which I just explained to you, any jail sentence imposed for the resisting arrest charge would by law be served concurrent with the prison sentence. So they cannot be served consecutive. Consecutive means one after the other. You'd serve one term first, then the other. Concurrent means you serve them both at the same time. Any misdemeanor sentence imposed with a felony sentence has to be served, if it's a prison sentence and the felony, has to be served concurrent with that prison sentence. Do you understand that?
All right, I do.
So your maximum prison sentence you face in this case is 12 months.
Understood, Your Honor.
Are you currently on probation or parole to any other courts or agencies?
I am not.
Do you have any other charges pending against you anywhere?
I do not.
If a prison sentence is imposed on count 2 here, upon your release from prison, you could be placed on what's called post-release control. We sometimes call that parole. What that is, it's a period of supervision you'll be on after you serve the prison sentence in its entirety. And in this case, it could be up to 2 years. Do you understand that?
I do, Your Honor.
And if you were on post-release control and you ever violated any of the conditions of your supervision or the rules, the parole authority can return you to prison as punishment for violating the rules for another 9 months for each separate violation you committed, up to an overall maximum of 50% or half of whatever the prison term was imposed by the court. Do you understand that?
I do, Your Honor.
Now, aside from the possible prison sentence, there's other sanctions that could be ordered. You could be fined on the count 2, the harassment with the bodily substance charge, up to $2,500. On the resisting arrest, you can be fined up to $1,000. So there's a maximum possible fine here. We're talking about $3,500. You could be ordered to pay court costs. You could also be ordered to reimburse the county for any cost of confinement, community supervision, or treatment, if any of that were applicable. Do you understand that?
I do, Your Honor.
I don't know if there was any testing involved with the officer from count 1, but if there was, you could be responsible for the cost of those tests also. Do you understand that?
Yes, Your Honor.
Now, a few moments ago, I explained the possible prison sentence you face. I used the word possible because prison's not mandatory or required here in this case. Now, these charges, with these charges, you are eligible for probation, what's called community control sanctions. Do you understand that?
I do, Your Honor.
Do you understand that just because you're eligible doesn't mean you'll automatically be put on probation? It means I'll consider that if that's what you're asking for. I'm going to look at all the information that gets presented, then I'll make the decision that ultimately I think is the right thing to do. Do you understand that?
I do, Your Honor.
Now, if you are put on probation, it could be for up to 5 years of supervision. As the judge, I do have the discretion to order a wide variety of rules and conditions for you to follow. One of the conditions could be an order that you serve a term in our Lake County Jail of up to 6 months as a condition of your probation. So if you get probation, that doesn't automatically mean there's no incarceration. There could be local incarceration in the jail for up to 6 months. So that's not mandatory either, but that's a possibility. I need to make sure you understand that. Do you understand that?
Understood, Your Honor.
Further, if you're on probation and you ever violate the rules of probation or the conditions from this court, we will have a hearing to see if you're what's called a probation violator. And if I determine that you are, I could extend your probation up to 5 years, if it wasn't originally 5 years. I could impose more restrictive sanctions against you, or I could terminate your probation and send you to prison. If I sent you to prison, at that point, again, it would have to be on count 2, and it could be for 6 to 12 months in prison. You understand that?
Yes, Your Honor.
Lastly, when we do come back here for sentencing, you're going to have the right at that time say anything you want. Anything you want me to know or consider, your lawyer can speak on your behalf, and she's allowed to recommend the sentence to the court and present whatever information she wants me to consider. Prosecutor can also recommend the sentence to the court. Do you understand that?
Yes, Your Honor.
Do you understand that whatever anyone says at sentencing regarding what they think the sentence should be, it is just what I said. It's a recommendation. I'm not required or obligated to follow that. Even if it's agreed to, I don't have to follow that if I didn't think it was the right thing to do. Do you understand that?
Yes, Your Honor.
All right, well, do you have any questions at all about the potential penalties you face by pleading guilty?
No questions, Your Honor.
Understand all the possible consequences?
Yes, sir.
Do you still want to plead guilty?
Yes, sir.
Have you had enough time to go over this case with your lawyer and have her review the reports with you, discuss whatever issues there are, answer your questions?
Yes, Your Honor.
Are you satisfied with her advice and counsel?
Yes, absolutely.
Has she or anyone, for that matter, made any promises to you about what's going to happen at sentencing, which is inducing you to plead guilty?
No, Your Honor.
Have you been threatened or coerced in any way to plead guilty?
No, sir.
So are you entering this plea freely and voluntarily?
Yes, sir.
All right, Dad. Do you have any questions for me at this time, Mr. Lee, regarding anything I just chatted with you about, the rights you're giving up, penalties you face, what you're pleading guilty to? Any questions at all for me?
No questions at this time, Your Honor.
Do you need any more time to speak with your lawyer before you enter your guilty pleas here?
Maybe a moment.
Yeah, go ahead.
Okay, so back to still the original what we discussed.
Yeah.
Okay.
Yep.
Thank you. All right. Yes, Your Honor. I'm ready to answer that.
All good?
Yes, sir.
All right. Well, what's going to happen at this point, then, the prosecutor here, excuse me, is going to explain for me what he believes the evidence would show if we had a trial regarding these two counts.
Yes,
I want you to listen to him and what he says, because then I'll have some questions for you about that, all right?
All right.
Thank you, Your Honor. Your Honor, I had this case produced the trial facts that are shown on the 7th of July, 2023 in the city of Willowick, Lake County, Ohio, outside of the Bogside Pub. Willowick police were called, as well as Whitfield police, to respond to an incident occurring outside of the parking lot. As part of that incident, defendant's sister was ultimately arrested. Her arrest caused the defendant to become highly agitated, getting into the middle of the arrest between the officer and the sister. As a part of that, the defendant was ultimately placed under arrest himself. He resisted arrest on the ground, ultimately spitting at the officer, making the arrest. The officer in that case was Officer Cook. All this again took place on the 7th of July, 2023 in the city of Willowick, Lake County, Ohio.
Thank you. Mr. Lee, were you able to hear what the prosecutor just had to say regarding what he believes the evidence would show if we had a trial in this case?
I was, Your Honor.
What, if anything, do you have to say about those facts as he presented them? Are they true? Did you do what he said regarding those two counts?
I can agree to the truthful. I can agree to the truthfulness of the statement. Yes, Your Honor.
Very well. Then regarding count 2, charging with harassment with a bodily substance of felony to the 5th degree, what is your plea to that count?
I do plead guilty.
And regarding count 4, charging with resisting arrest, a misdemeanor of the 1st degree, what is your plea to that count?
I plead guilty to that as well.
All right, I have in my possession at this time a 4-page document called a written plea of guilty and judgment entry, which explains everything we've just gone over. Before I can accept your plea, I need to make sure you understand what it says in this document, that you sign it here in open court. Now, my understanding is before I came out here on the bench, you had a chance to go over this document with your lawyer. Is that correct?
Yes, sir.
Ms. Hibbert, is that accurate? Did you read this over with Mr. Lee and review it with him?
Yes, Your Honor.
And in doing so, did he indicate to you an understanding of what was in the document?
Yes, Your Honor.
Is that correct, Mr. Lee?
Yes, sir.
You understand what it says?
Yes, Your
Do you have any
Honor.
questions for me about the document?
I do not at this time.
Now, on the bottom of the 3rd page, it appears that you signed the document. Did you, in fact, sign it?
I did, Your Honor.
Ms. Hibbert, did you witness that?
Yes, Your Honor.
Mr. Foysel, you as well?
Yes, Your Honor.
Very well, then. At this time, the court will accept the defendant's oral and written plea of guilty. Let the record reflect the defendant was here in court with his lawyer, advised of all his constitutional rights, and made a knowing, intelligent, and voluntary waiver of those rights. The court also finds the defendant understands the nature of the charge, the effect of the guilty plea, as well as the maximum penalty that can be imposed. Finding this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea. Find the defendant guilty of count 2, harassment with a bodily substance, of felony to the 5th degree in violation of 2921.38b, as well as count 4, resisting arrest, a misdemeanor of the 1st degree in violation of 2921.33b. Counts, looks like 1 and 3 will get dismissed as agreed to. That'll happen at sentencing, though. But sentencing is deferred. I'm going to Order a pre-sentence report investigation, victim impact statement. Any of the reports that you're requesting, Ms. Hibbert? Is there any issues with drugs or alcohol that need to be explored?
No, thank you, Your Honor.
All right, so we'll just have those two reports. I'll continue bond of $5,000, cash surety or 10%. So what all this means, Mr. Lee, as far as your bond goes, I'm continuing your bond. There's nothing more you need to do about that. You've already posted the bond and signed everything. One of the conditions of your bond is that you don't use any drugs. You'll have to continue complying with that, as well as all the conditions of your bond. You may be requested to submit urine samples. If you are, you have to submit those, and if they're positive for any controlled substances, your bond would be revoked and a warrant would be issued for your arrest. Do you understand that?
Yes, Your Honor.
Now, the purpose of this pre-sentence report is so I can learn more about you before sentencing. The way we get that information is that probation department is going to conduct some interviews with you. They'll administer some tests. It's important that when you speak with them that you're open and honest with them, because they will check and verify everything you told them. And if they learn you're misleading them in any way, whether that's minimizing or embellishing something or flat out lying, they're going to let me know that, and I would obviously consider that as sentencing. You understand that?
Yes, Your Honor.
All right, so you're going to leave here right now. You're going to go over to the probation department, fill out some initial paperwork, and get dates to come back for your report. Make sure you go there when you leave here.
Yes, sir.
All right. Any other questions or any other issues you need to address, Ms. Hibbert?
No, thank you, Your Honor.
Mr. Foysel?
Nothing further, Mr. Chairman.